Let's top this morning off with business and immigration law updates. This is a proud presentation of the Khurana law firm, which is headed by attorney Ramesh Khurana. On this set, the moderator is attorney Kenneth Haber from Boyd's, Maryland. Here, attorney Haber questions attorney Khurana on the saga of the grace period in immigration context. Let's take a look.
Welcome. My name's Kenneth Haber. I'm a former Assistant United States Attorney and I'm a former Senior Attorney in the Office of Inspector General of the United States Department of Health and Human Services. That's the Medicare cops. I was there back 79 to 83 when it was just getting on its feet, and now it's full-fledged. Even more full-fledged is the immigration attorney that's sitting next to me, Ramesh Khurana. Welcome, Ramesh.
Thank you so much.
Ramesh is here to discuss various immigration issues for you on the Capitol Forum. Ramesh, welcome. Thank you for coming here.
Thank you, my dear friend. I appreciate it.
Well, we appreciate you.
I'm here to answer your questions.
Well, we're going to pepper you with them.
Oh, definitely. Most welcome.
Ramesh, can you describe grace period concepts within the context of immigration?
Sure. Can most of the people who are here in the United States legally on different kinds of visa petitions, maybe H-1s, L-1s, F-1Js, and other types of visas, and they think that there is always a grace period if they run out of the approval time of H-1B petition. Now, what happens is, this concept is very important to know. If your petition is approved, let us say up to March of 2016, so that is called the authorized stay by the Secretary of State. Earlier it used to be Attorney General, now it's called Secretary of State. So if you go beyond that period and you do not have any approved immigration petition, you start incurring unlawful presence. And unlawful presence is very damaging, because if you have been here unlawfully for more than 6 months to less than 1 year, you are barred from entering the United States for 3 years. And if you are unlawfully present for more than a year, you are barred for 10 years unless you are eligible for some waivers, which are available under circumstances, which is the topic of discussion for some other day. So that's a very, I would say, fearful situation when people run out of status. So that's why they always think that there is some grace period. But in most of the situations, there is no grace period with a few exceptions.
Wow.
Yeah.
People get themselves in real trouble that way.
Right. Exactly.
If they're out of grace, then that adversely impacts, because there is no grace, that adversely impacts their petitions that haven't been filed already, doesn't it?
That's right. Because if they are filing for change of status or they are filing for extension of status, they are just not eligible unless you fall within those exceptions.
If you file beforehand for a change of status, then you're okay.
Oh yes, before you go out of status and before that particular date, your another immigration related benefit application or petition reaches the USCIS, you are fine.
Because you got your petition in.
Yes.
Timely.
Yes.
But after that time, you're out of status and you're
out of
there
status.
Is no grace.
Yes, out of status there is most of the time there is no grace. Yes.
Then you have to leave the country before you can apply.
Yes, definitely.
Wow. What's the specific situation as far as foreign students on a F-1 visa?
So when I said there is no grace period with just a few exceptions, not people who are on F-1 visa status. Now there is a grace period.
There is on that.
And there is a grace period of 60 days. Within 60 days, basically they expect you, either you should be getting ready to leave the country, but within 60 days you can even file for change of status.
I see.
So that is possible.
So if you can get a quick marriage going, then you can
Yeah,
do a
something,
change of
you are
status.
filing H-1B petition or L-1 petition, depending
to
upon
us.
your eligibility. Now, when you are talking about the quick marriage, if a person who is on any kind of non-immigrant visa status, H-1B, L-1, F-1, barring certain situations of J visas where home residency requirement is there because of INA section 212E, if you get married to a US citizen spouse, the only key factor to be seen is whether you enter the United States with inspection. That means you had a legal status at the time of your admission to the United States. If you have an I-94, which even permits you for a single day, and then you fall out of status, but you are marrying a United States spouse, then you are good to go.
Good to go.
Yeah. Or else you are the parent of a US citizen child. Even though your visa status has lapsed, still if the green card petition is filed for you, you can adjust your status.
That means my wife's lawful, huh?
Yes, that's true.
That's right.
And likewise for J1s, there is a grace period of 30 days, since we are talking about the grace periods.
Very good.
Yeah.
You know, I have a little story about immigration. We were doing her interview. You know, everyone has to go get interviewed when you're going in for the marriage. And we get into an argument. I don't remember what it was about. Right in front of the immigration officer who was interviewing, and she said, "Stop. You don't have to go on any further." She said, "No one who's faking it would get in an argument in front of the immigration interviewing officer."
Exactly. Officers are very sharp, they are well trained, because basically when they look into your eyes, they can find out whether it's a real marriage or a sham marriage. And especially as you rightly said, if you start arguing, and these are natural arguments, not that you have been trained to do that, and they can see it, you know, like they will not think that it's a sham marriage.
No, it wasn't. We're married 12 years now.
Right. Yeah.
Yep. They're,
I
they're
agree
very
with
astute.
you. I agree with you.
What about the H-1B visa? 10-day grace period?
You know, for H-1B visa holders, there is no grace period.
There is none.
Now, there is a situation when a person can have a 10-day grace period when you ask for it at the time of entry into the United States. Then it can be given only in that circumstance. But if you are in H-1B status, let us say you lose your job or you are laid off and your income stream stops at that point, you do not have pay stubs to support your status, that's the end of the story. So you go out of status.
So what you want to do when you're coming in, ask for the grace period just in case you get fired without any notice.
No, you cannot ask at that point of time. Grace period you can ask only when your period has lapsed. Then you say. But here, when you are coming on H-1B, let's say that you have 2 more years left. When you are admitted to the United States, you are good for 2 years. But unfortunate situation happens when you are fired. And in that kind of situation, there is no grace period. Technically, you go out of status same day. So, but there is a way out to help these kinds of people in that situation.
Yeah, quickie marriage like my wife and I.
No, that is of course, but most of the times these H-1B visa holders, they may be married already. So what they have to do is, we call it a consular processing. If they find another employer who's willing to file an H-1B petition, we will say approve it, and the person would go out of the country and he will be interviewed by the consulate or US Embassy abroad. Then he will enter on H-1B petition for another employer. So that's the possibility.
Right.
But if you want to file an extension petition here, you are required to demonstrate that this person is in good status, and how you are going to demonstrate is by way of your pay stubs.
And if you're fired, you don't have pay stubs.
You don't have pay stubs from that date. Your income stream is cut off from that particular date.
Right.
And if you lie, then you invite more trouble for you.
Exactly. So that's why the quickie marriage was a good result.
Of course, if that works, nothing like
Well,
that.
we were in love.
Yeah. But I know in regard to business immigration, as I said, in this kind of situation, we always ask for consular processing.
That's right.
Yeah.
That's right. What about whether or not filing an appeal or a motion to reopen or reconsider the status, a person's lawful status? What's involved in that?
Yeah, Ken, this is a very good question, simply for the reason. Now, there is a misconception among most of the people. When the petitions are denied, USCIS would say that you have 30 days to file an appeal or motion to reopen or reconsider, and 30 days plus 3 days for mailing if the denial notice has come through the mail. So, you basically have 33 days. That does not mean that you are allowed to file an appeal or motion that you are in good status. Your status is already gone. So, filing a motion to reopen, reconsider or an appeal does not provide you a bridge to stay in good status, unfortunately. So, most of the people don't think that they have gone out of status, but unfortunately this is what happens. That is why I always say talk to a competent and knowledgeable lawyer, so that you know your situation very well.
That's right. Somebody who's very experienced.
Yes, person has to be very well experienced. He knows how to handle a particular kind of situation so that he can put you on the right path.
Absolutely. You know, immigration work is as complicated as tax or securities work, and certainly as complicated as healthcare, Medicare work, and you know, you got to really be experienced in that.
You said it right, Ken. Really, immigration laws are very complex set of rules, and then guidance keeps on changing every day. You know, memoranda are issued by USCIS, Associate Director, in regard to their respective fields. So, you have to really track down this kind of information. It changes overnight. Filing locations keep on changing very frequently. Even the forms which we have to complete for seeking any immigration benefit, they are changing very frequently. So, you have to be sure that you are using the right addition which is acceptable. I have come across certain situation where certain lawyers handled some employees' petitions, and they did not use the right type of application form or the addition which was acceptable, and the package was rejected. By the time it came back, the person was out of status. So, out of luck.
They might have been the corporate attorney who thought that they can do anything.
Right, exactly. So, you should really talk to a competent lawyer so that your interests are fully protected.
I think that's appropriate in most fields, and especially in immigration, that they need to get an immigration attorney who really knows immigration law, not just you know, some sort of general business attorney.
I agree with you, Ken.
I'd like to thank you very much for coming on in and elucidating on these topics. And remember, this is the Capitol Forum.
Thank you, Ken. Again, last but not the least, whenever you have some immigration issues, talk to an experienced and knowledgeable lawyer. Thank you so much for being with us. And thank you, Ken.
Thank you.